Artificial Intelligence, Law and Justice. This is session 38 and the topic is AI, Law and Justice Beyond Technosolutionism. Let us do a recap of the previous session. The last session we explored how AI tools including generative AI can be used to democratize access to justice and information and why they have to be assessed and how to assess them. In the sense that we did recognize the potential, huge potential that remains unexplored and then how to use it responsibly. Moreover, we also introduced a new concept called equitable access to AI in law and justice, and then we also discussed as to how to move towards it. In the sense that how do we realize it. In this session, we will take forward some of those ideas and also introduce some new ideas also, so that when we end up this session, we will have had a better idea, understanding on how we can look at AI from a different perspective as well. So, legal technology and self-help services are not new. But what is new is that legal technology can significantly change how legal services are delivered. In the sense that it is possible to deliver user-friendly different apps, different programs and then other web-based services to the users. And then these have the ability to lower the prices and increase access to justice. Since AI is recognized as the necessary driver for transformation, this potential has been widely discussed in the literature, particularly in the context of how this can be used to address the digital divide in AI and law and justice. One way to do that is that access to information is critical. So people can be induced to get access to information by giving them self-help manuals and other things. So essential for justice is that we don't need always go to a court or lawyer to understand what is the issue or how we can go about it. So access to legal information itself will propel people to seek information and then to take their claims or to stake their claims. And then there is a huge history of legal self-help which is available as how-to manuals for consumers and then for different people. Like if you are a tenant, how do you deal with that? If you are a laborer, how do you deal with that? If you are a small businessman, how do you deal with that? And these are available in many languages across the world. And modern self-help methods are something very different in the sense that there you go beyond the manuals. There are some guided interviews for users where users can ask questions, they will get responses, and then based upon them, subsequent responses can be tailor-made for them. So the self-help market can be really tapped for legal service provision through AI. But there are some problems here. First of all, generic tools often may not be very user-friendly or relevant for many people because we would need some industry-specific needs. Then some of the tools which have been built specifically for the people who can afford or privilege may not suit the underprivileged or who lack access. And then it is also possible that these tools might have excluded certain groups in the training data. So when the design purpose itself takes care of some of these things and then also identifies the target user group and then it is developed, then it is easy for us to understand as to how these things can be worked out. Another issue is that often what happens, undigitized records are not included. As we have seen earlier, digitization is becoming an essential component in law and justice. Still, including India, many countries have a long way to go. So often what happens, the programs or the tools or the systems rely only on digitized records, leaving behind a whole lot of undigitized records which are also equally important. So this exclusion can also limit the utility of the AI tools and then chatbots and other things. So since this reliance on digitized tools may in fact impact the marginalized communities little negatively, and then they may not be able to really understand or get access to them. So one way to address this gap is to enhance the scope of the digitization so that digitization covers completely all the available and necessary records. Other way is to help the communities which don't have digitized records but which have records available to them, help them to get this digitized or at least help them to understand as to how they can go through them, read them and then input the same information in chatbots or in some other self-help tools. So we need to really calibrate for AI for legal processes, because when we mean calibration, we know that there could be issues in automation in AI and legal law and practice. So we need to understand as to what could be the potential problems and try to solve them. So the democratizing legal expertise through apps is a one way to address this. And then mass market problem solvers apps aim to make legal expertise accessible. In fact, there are many apps which also give the fundamental legal rights, fundamental legal questions are being answered. But the problem with these things or the issue here is that while they are generic and while they're extensively used and then applicable, they may not be able to fully address each and every issue, and some issues may require human input or some human input in the sense to get a better understanding. So calibrating AI for legal processes also means that we need to look at the instances where we need to go beyond these generic apps and then other tools. One more problem is that how sophisticated will be the consumer to understand them. Because there is one issue called digital divide. But then there is also another issue where digitized technology needs a steep learning curve from people. In the sense that not all will be familiar with them, and then coming to understanding these AI tools and then how to use them is not a simple task. So the complexity of the legal tools also makes it somewhat difficult. So unless the consumer is really sophisticated, he or she may not be even able to try some of them. So one way to address is that to make all sorts of tools available to consumers, some of them even the preliminary one where people can start with some confidence and then learn further and then move up in the ladder. So the consumer sophistication should be taken into account while these tools are being designed. But another question is that how will the consumer know or the individual know that legal tech has succeeded? One way to test is that when we develop apps, when we develop different tools for consumer education or information dissemination purposes, there should be an evaluation as to how much of that the consumer has grasped or how much as the consumer has been able to pick up and understand. And then based on that, we can identify areas where consumers lack understanding but not able to really put them together. So these sort of evaluation, inbuilt ways to assess should also be part of that. Another issue which is equally important is that technology in the initial client triage. Now what is triage? Triage arose in a military context where in war, when there are a lot of injured soldiers whom should be prioritized to get treatment or treating whom should be the first priority so that that person can get quickly treated and then fight back. So the idea of triage in one sense is that how do you allocate resources when there are multiple claimants or when there are people who want the same access to resources, although the resources are very limited. But the problem is here, since not many will be tech savvy or have the familiarity with technology, technology may act as a gatekeeper to begin with. However much we try to make digital services accessible, make them user friendly, this sort of gatekeeper issue will always be there. So there could be an initial triage where the consumer will be the one who may need it most. But then since that consumer is not able to really come to grips with the technology or deploy it usefully, the consumer's reluctance or the wrong answers or the inability to deal with may result in a triage situation, where the ones who need it least may get the opportunity to work with the technology. A similar problem would come when a legal service authority also faces AI-based law and access programs made available to a large section of population. So in that case, some attorneys will be served well by some clients, whereas for many of them, since they are not tech savvy even to identify how they should go about, they may feel left out or they may get excluded. So this triage issue can be tackled successfully by broadening the base of the available technologies and then by ensuring that those who need it most, their needs are taken into account first, and even if they are digital illiterate or even if there's a digital divide issue, that should be overcome through some other things like giving people printed manuals, giving people other modes of educating them to come to understand the digital tools and use them. Now, we need to also look into the core values in AI. What are core values in AI? Unfortunately, what happens is that the core values in AI do not get much reflected in the discourse on law and justice. Often, we find that the technological allure, the potential of technology to do massive changes for paradigm shift and all, overshadows ethical concerns and other issues. So, we need to identify the core values in AI discussions when it comes to law and justice. Then the problem, particularly in criminal legal system, is technology is often seen as a solution to value-based problems. Now, the value-based problems could include transparency, lack of access, accountability, and all. So, people think that technology can be made better, can be made easily available. People can be made to work with them, can understand them, and then can get benefit to address as a solution to some of the value based problems, but the value based problems are much more deeper, and then technology is necessary but often may not be sufficient to address them. Another major issue which we face, or for that matter anyone in this digital age faces, that there is huge information available today. I mean, in the sense that there is no dearth of information today on anything. But when legal tools are to be deployed, they should not end up in being giving an information overload to the consumers. So the consumer should get only the adequate information, or consumer should not be deluded into consuming too much of information, and then that again getting them confused or making them uncertain as to what to do next. Because here also the problem is that often we mistake that more information, better information, and access to information is better, will lead to better policy. It need not be always. Because more information again may also result in more confusion or more clarity, less clarity, and then more ambiguity. And abundance of data or abundance of information is not the full solution to the issues that arise on account of values. So we need to look at the core values and AI, and then identify as to that how we will not get bogged down by information overload or having too much faith in technology that we ignore the values issues. One of the recent developments is that we can use electronic monitor instead of putting people in jail. Or a small anklet or a small device can be tied to their feet or to their hands, and then they can be asked to move freely, or their movement need not be so much restricted. Those anklets or those devices will continuously can be monitored. They will be sending signals, and then as the person moves from one place to another, or as a person sits in one place, it will be easy to really locate as to where that person is there using the geospatial profile available in the device, including many, even cell phones have that option now. So this is possible that this electronic monitoring and then the relative risk assessment can be brought into the criminal system on a full scale. For example, in the USA, it is estimated that at any given time, about 5 million people are under community supervision. Community supervision means that their movements are being supervised. They know where the authorities will know, or the person who monitors them will know where they are, what are they doing, and that person will also know that as to what exactly should be expected from them, as to when the person will return to the person, or when the person will come back to the person once this is over, or what conditions the person will be violating if he disassembles the device, or if he tampers with the device. So for people who are undergoing probation and parole, these devices are useful to monitor. And then AI can really give a real-time assessment of risk and need for them. In the sense that we can use AI to monitor them, to identify the real-time risk and the need to assess them. So this mobile service delivery, intelligent tracking of individuals is much better facilitated by AI. And then this again has got both positive and negative aspects. The positive aspect is that it enhances the freedom, it gives them mobility, it also ensures that they are not unnecessarily kept in prison for long term, in the sense that it does give them some justice and freedom. The negative is that often these wearable devices become stressful, or people always think that they are being monitored, or there is a big brother who is watching them irrespective of where they are. And then when this is combined with biometric, in the sense that the person who is wearing that monitor or a device has to use biometric criteria or has to give the biometrics in different circumstances, then it becomes an extended surveillance. And then that also adds to the stress of the person. So the AI enhanced devices can circumvent some of the problems by tracking people without having too much of surveillance over them. But then the downside is that AI enhanced devices can also enhance the scope and then the breadth of the surveillance, because AI enabled devices can be tailored in such a way that that person can be monitored 24/7 without that person being even aware that all his movements are being monitored. So we talked about values. What do we do then? We need a values framework for AI. The Smithsonian Institution came up with AI value statements that emphasizes the point that technology is not neutral. Of course, the values framework, ethics framework in AI are not new. We have even seen that many private entities, many organizations, consulting firms, many developers of software, AI systems have their own in-house developed ethical guidelines, value guidelines, responsible AI principles and all. So we need to have a values framework that can facilitate engagement, where we prioritize value over technology, or we do not see technology as the solution for all the problems. Particularly when the criminal legal reform is more interested in predictive assessment of algorithms, we need to look at what are the values that will guide those development of the devices. And then will the values guide us that there is no algorithmic injustice or nobody is unnecessarily punished by the algorithmic decision making even without they being aware of it. So this is again transparency, accountability, responsible AI, explained AI become very important. But unfortunately, there is not much discussion on guiding values for evidence-based information, or how do we integrate them in the criminal reform session where AI seems to have a greater potential in both monitoring as well as in other ways. Electronic monitoring is not new. It was developed in the early 1970s for military and civilian partnerships. First, it was used in 1983, and the electronic monitoring is seen as an alternative to mass jailing or putting too many people in the jail. But some people consider that this is not an excuse, this is not an alternative, because by another way it is extending people being jailed in different form. And then the associated harms people have to be made aware, so they need to be mitigated. But the problem here is that, as we have seen earlier, implementation includes large complex risk assessment algorithms, and then they are not often guided by any value framework. They are guided by more cold logic, more by statistical patterns, and by systems which are opaque. So transparency, fairness and well-being need to be brought in as core values. But the criminal legal reforms has a unique issue here, because the technological complexity of AI is much more greater than the previous ones. Electronic monitoring was relatively more easier to understand than implement. But then AI systems, AI's complexity defies easier understanding, and then there are also a whole lot of concerns about to what extent AI should be used in criminal law and justice system, and whether the use of AI is the best or optimum solution under all circumstances, or how to combine non-AI systems or non-AI solutions with AI solutions so that best of both can be arrived at. We have talked about the bias, we have talked about the thing, but we can also know that we can use AI to identify the biases. AI can analyze laws, AI can analyze documents, AI can analyze faces, this and all we know. So using that, it is again possible to identify linguistic patterns and then criteria that encode racial biases or gender biases or biases against any community. For example, if a linguistic pattern in a text or in a legal document or in some other guidebook or something repeatedly refers to a certain section of people by a coded word or by the slang word or by something that is considered as demeaning or insulting, then there's a major problem with that. So the language which is being used in the manuals, in the devices and other things should be thoroughly checked to promote equity. Then AI datasets can be used to identify harsher, whether people have been really given harsher sentences than what they deserved. So when that is being done, when the AI itself is being used to identify the harsher sentences, and then whether was it on account of bias compared to with the other control groups, we are putting AI into a different sort of use, which often AI people may not even think that it is possible. So using AI, we can think of a advocacy for new sentencing guidelines where AI will help to understand and then to eliminate the biases. And then AI should help people to draft with petitions to understand and then come up with their own statements and then other valuable records so that they are able to apply for clemency petitions and then release petitions. So when there is a huge volume of these things to be decided or to be worked upon, AI tools will come handy when the criminal justice system itself is overburdened with too many demands and then too few resources. So the pre-trial process can be transformed with AI-based systems where they can identify the scope for parole or scope for bail, or they can identify the potential problems in that person getting a bail or a parole, or they can also identify as to what exactly the person lacks and then how the person can address the lacks or what address the defects in his petition or in his appeal and then try to help that person. So AI tools can be used to identify, eliminate, and then to mitigate the issues arising out of bias. But we should also be prepared for unintended consequences of AI. See, unintended consequences of any technology is something which we need to take granted. In the sense that nothing could be predicted, nothing could be seriously say that nothing else will happen. So the unintended consequences could be that they may not be a very direct negative impact, but then positively impact is also possible. But then there could be some sort of indirect negative impact which was not anticipated, or a diminished positive influence which was not expected when the system was designed. So unanticipated, unintended consequences we need to really look into, and then they see as to whether these unintended consequences makes things worse for people or whether they contribute to the existing disparities and inequitable access. So the problem is that if we are going to extend the carceral system or the prison system by use of AI beyond physical facilities, then there are two ways to that. One way to look at is that it does enable a lot of positive things to happen. People need not be confined to prisons and jails for longer period. They will get some freedom, they will get some liberty to move around, they can serve in some community, they can also have some rights restored. But this comes with a cost that they could be put to under specific and more surveillance in some context. So unintended consequences or intended consequences or not, some of these issues may have some psychological impact on the persons who are affected, in the sense that it can affect their sense of well-being. They may become paranoid, or they may think that much more than monitoring, something else is also happening through the tools that are used to surveil them. So these unintended consequences and then extension of the algorithmic electronic monitoring and all need to be done with careful, need to be done only when it is a must, so that people are not unduly burdened by extra surveillance. So the values framework, we have discussed about it, and then that could be easily brought in. So the nature of technology is that over-reliance by technology in many systems can result in overconfidence as well. So this need to be really looked into, but we should also understand that technology is more than a neutral tool. And then the historical perspective on technology as rule, which we have discussed in one of the earlier classes, also tells us that technology cannot be taken as a neutral tool anymore. And then the problem with AI is that it poses a unique and complex challenge because of the huge potential, and there's nothing like a technology AI with which the criminal justice system has encountered in the earlier years. So there is a need to have competence in the technical arts and sciences, and then also to understand the relevant values, and then to harness AI through human values, and then to minimize the potential harm. So these are some of the ways to engage with the AI systems in criminal justice system. Having discussed all this, we will now introduce few concepts. One is the technofix. A technofix is a technological remedy for social problem that only involves minimum use of political power or economic incentive to change on individual's behavior and does not require changing social norms. So here, Instead of changing people's behavior or instead of changing social norms, those changes were not advocated or not even suggested. So a technology-based solution is being put forth there as a sweet technical solution that could be implemented without the society undergoing values change or the overall system not need to undergo any further change. Solutionism is a way of thinking about problems where the confidence in the human reason and then our capacity to implement numerous strategies for overcoming obstacles and capitalizing opportunities, typically through a course of action, including technology, that significantly alters social norms. So solutionism is the approach that we can quickly find solutions for all the social problems without trying to alter too many of the social norms or the societal structure. Technology solutionism is a very specific technology-driven approach where it is rooted in the Promethean optimism towards the technology and then the potential of the science and technology to transform things. So technosolutionism sees that AI is the best solution for many problems in law and justice as much as when we need to think in terms of solutions. So a technosolutions perspective will be that despite issues or not, AI is the one that should be relied upon most when it comes to law and justice. Again, a techno-solutions perspective will try to say that we need to be optimistic about the revolutionary potential, the initial hiccups or the starting troubles or some of the issues like bias and then bias, discrimination can be tackled as the technology improves and then technology can solve almost all the problems. So technosolutionism is at the heart of most of the discourse where you find that people uncritically accept that AI is the best thing technology that can solve many of the problems with law and justice, including pending cases, pending judgments, the backlog in cases, the judicial delay, and then various other issues. But the problem is that the real world is very messy and then the neat technical solutions often do not fit well over there. Those who argue for more AI tools, more data and better AI integration law and justice need not necessarily mean that they are for techno fixes and techno solutions. But in the literature, you would find that by default or there's an implicit understanding that they are in favor of techno fixes or techno solutionism. And then when people say that AI is the big beautiful solution for many problems, the allure of technology is such that we often forget that real world is too messier to be mapped and then understood through technological lens. More importantly, as anyone who has dealt with law, courts and justice will understand, that this is very true for law and justice. In fact, law and justice in real life is much more complicated than any other field. But no need to take extreme positions. We can still take a very pragmatic position on this issue, and that pragmatic position is that technology's potential can be compromised by many non-technical factors, and this should be factored in anything. One way to look at this is to decipher and then demystify the hype. So AI tools can make a huge difference, but then we have seen where the problems comes. Institutional values, long-standing practices. Again, democratizing AI is an ideal, but then there are issues because technology cannot be 100% malleable or flexible or made to do whatever we want. More importantly, unrealistic expectations from artificial general intelligence in law and justice may deter us in addressing the real problems that need better solutions. And we may also end up wishing and more for technology-based solutions than looking at the fundamental problems that need to be solved or the harder issues that elude simplified superficial solutions. So there could be a position that goes beyond the hype without undervaluing the role of AI in law and justice. One way to conceptualize is that Sayesh Kapoor and Arvind Narayanan, who are well known for their work AI as a snake oil, have come up with a very recent paper where they have tried to demystify AI itself and then claim that there are both utopian and dystopian views on AI, but better to look at AI as a normal technology. So AI is a normal technology. Future AI will remain a tool. It may not become a super intelligent entity. More importantly, we should look at AI as a controllable tool than a tool that will control us. So AI is not an agent in determining its future, or in other words, AI's future is not in AI's hands. Our technology is not something that will run out of control on its own. We are there to control and then direct technology. And then the past revolution, technological revolutions also reinforce this perspective. So we need to look at the continuity in social impact as to how the technologies have really had a societal impact in the past. While the impact materializes with improvements or transient applications, there are speed limits at each stage of adoption and diffusion on account of various technical factors. So, we need to look at gradual and then disruptive technologies. Often, the speed of disruption and adoption of AI go hand in hand, but not necessarily always. So, if we define invention as a development of new AI methods and innovation as a development of products and applications using AI, we should be able to differentiate between the applications as to whether an application is invention or is it just an innovation. Often innovations could be very incremental, very marginal, which do not in real world offer a great solution than what is already available, whereas an invention can be something that can make a huge difference. So we need to also look into the AI safety issues in AI diffusion in safety critical areas, particularly law and technology. And then what are the scope of AI adoption outside the critical safety critical technologies we need to look into. And of course, we also know that there are a lot of issues when it comes to real world, because what happens, AI methods progress as a matter of generality, and then programmers needs are reduced in terms of effort, task becomes better. Machine learning increases generality by using training samples. So there are some issues, but not all technologies which act as a constraint. For example, in self-driving car, the constraint is the duty concern. It is not the question of technology, but the safety concerns in self-driving cars is a real constraint over there. Similarly, in case of AI in law and justice, the concern could not be the technical issues. The concern could be whether the organization, individuals have the capacity to adopt and adapt, and more importantly, whether the people can really handle AI with carefully, responsibly, and safely. So the general models surpass human domain knowledge. This is very true. But then they also come up with hallucinations and other issues. But there are also limits to AI learning in the sense that we cannot expect that AI would learn everything and anything under the sun and would be the super computer or the super repository of all the knowledge in the world. More importantly, there are lots and lots of issues in benchmarking, forecasting the different models, because different models have different bases and then they also have different issues put together. So the economic impact in AI in law and justice, or for that matter from AI, may not be something very dramatic. It could be gradual, it could be on a very slow pace, but it will be very significant. So the speed of progress we need to really look into. So human ability is not constrained by biology. The sense that it is not the biology that really constrains us in terms of ability. Technology in fact enhances our ability to control the environment. But then it is also equally true that modern humans are super intelligent compared to pre-technological humans, because our intelligence today is much more sophisticated, much more diversified, and much more malleable than what of the previous generations. So it is not that AI has got great power, our imagination and intelligence has not raised or had stopped going. It is equally true that we have become better intelligent, we have become better handling of data, we know how to handle things better now than ever before. But the question with AI is not mere intelligence, it is the power of AI. So the AI capabilities, if not used properly, may result in loss of control. So preventing AI from significant power in law and justice is very important. So human abilities do have limitations, particularly in terms of speed, processing, and understanding. But then these human abilities with limitations are equally important in AI, because when they are there, they could act as a stop breaker, or they could be the ones that could intervene when the system has got the potential to go haywire or off the track. So adapting ideas from other fields will be important to understand how do we look at our ability vis-a-vis AI ability, And then looking at AI as a normal technology will give us the confidence that we need not be unduly bothered about the AI superintelligence, and we can work well with AI with a better understanding. So, this is the literature I have cited. Of course, the literature is huge, but the problem here is that in a course like this, like one can only simply touch upon and then explain a little. One cannot, for example, AI is a normal technology. This paper itself is about 52 pages, and then summarizing that in 4 slides is a huge task. But on the other hand, the key insights of the paper have been more or less captured here. So we need to look at the literature also with more depth, with a better understanding than merely going by what the literature on AI and justice says. We need to broaden our vision so that we get inputs from people with diverse backgrounds and then from diverse fields. The next session will be law, technology, future of AI in law and technology. This is something that will be in one sense a continuation of this, but then that's a totally new chapter altogether. Thank you.